quick question. So speaking of which, so let's say that you did bring an urgent motion, which to you is urgent, but the court staff doesn't think it's urgent when they triage. Do you have to pay a fine? Like, do you get penalized if the court? Okay.
Well, the only way you get penalized is your motion doesn't get heard.
Okay, well, if your motion
Oh.
doesn't, okay, right. So, but what about costs? I read somewhere that they said that if you're not successful in an urgent motion or something like that, you get
Oh,
costs.
well, okay. So what it
Oh,
means
we're
is,
gonna
okay, in
talk
that
about
situation, what you're talking about is one where, okay, let's talk about it. So let's
yeah,
say that you really think that you are in a situation that you should
yeah,
bring an emergency or urgent motion,
yeah,
and you do your notice of motion and
yep,
you do your affidavit and you
yep,
bring it to the court staff, and either the court staff or a judge reviews what
yeah,
you've done and said, no, this is not an appropriate situation for an emergency motion to be brought.
right,
You're just either start a normal application and go through the normal process, or
right.
if you're already in the process, wait for your case conference to occur. In that case, all that happens is you're not gonna get
No,
your motion heard.
you won't get hurt. Yeah, so
It's
that's
just,
okay.
then you go
Right,
back and you go back onto the normal track for
right,
how you proceed if you need to get an order to change something. It's not an urgent or an emergency motion.
right.
But let's say that you do your emergency motion,
Yeah.
or it's accepted, and you get
Mm-hmm.
before the judge and you argue your motion, but you're not successful.
Yeah,
If it's on a without notice basis,
yeah.
the judge will probably just dismiss it because the other party is not even there. They haven't
I
been put to any
see.
expense or hassle or
True,
trouble
true.
or anything,
Right,
because you've just gone ahead and done it completely on your
right,
own.
right,
The other party doesn't even know you did it,
right.
so there's no grounds for ordering
I
costs to the
see.
other side.
Makes sense.
Um, but let's say it's one where it is an emergency motion that you did serve the other side with the documents, though.
Yeah.
They file their responding material, and on the basis of the materials that are filed and
Yeah.
hearing what has actually happened and what each of the parties has to say, a judge says, I'm not granting this emergency, I'm not granting the order that's being requested. I don't
Right,
think it's appropriate. I don't think it should be done.
right.
Then in that case, then well, again, either party, if the person that brought the motion is successful and they've asked for costs
Yeah,
as part of their motion,
yeah.
and they're successful in getting what they've asked for, they can ask for an order for costs.
Right.
If they've served the other party has had to respond and has filed responding material and has to attend and argue. And it turns out that the responding party is successful.
Yeah,
The emergency order is not granted. Then the responding party can ask for costs
right.
because they've been put to the trouble and expense of doing
Yeah,
something that they successfully defended.
right.
But as all cases are, when you go to court and you ask for costs, the court may decide that even though one party was successful and the other wasn't, it's not a situation where they feel costs are appropriate. If the
Right.
court really genuinely feels there was an issue to be heard and both parties did the best that they could, and neither party did something that was really blameworthy or anything else, just the
Mm-hmm.
fact that you are successful doesn't mean you're automatically going to get costs.
Oh, I
And
see.
again, quite often I've seen, because emergency motions are generally brought because it's something about a withholding of children, or children
Yeah,
are being removed or
right,
taken away, or things
right,
are being done with the kids that are going to deprive a parent of their parenting rights.
right.
Then a court will usually say, no, this was something that should have been brought before the court. We're dealing with the best interests of the kids. We're not going to make an order for costs either way, even though one party might have been successful or not, because hopefully both parties will have learned a lesson from this and they'll know what to do and how to behave in future.
Okay.
Yep. And again, so, and the way it would work, if you had to serve your motion materials on the other side, I have seen cases where somebody has brought what they thought was going to be an ex parte urgent motion, and they bring it to the court and the judge says, I agree, this has to be heard as an emergency motion,
Mm.
but I want you to serve the materials on the other side, and this is the
Oh,
date the people are going to come back and you're going to get it argued.
oh,
So
interesting. I see.
there are other judges that might look at it and just say, nope, I'm not gonna, this motion doesn't meet the requirements for an emergency motion without notice, so you're gonna have to start all over again. And like I said,
Mm.
it really is dependent from, not only from jurisdiction to jurisdiction, but it could even be from judge to
Judge
judge
to
within an
judge. Yeah,
individual court,
wow.
and see how it goes.
Okay.
But as I said, generally, if you've gone on an ex parte basis, the court may hear it without giving the other side notice. Or they might say, yes, this is an emergency motion, it should be heard, but I want to hear from the other party before I make a decision. So I'm going to adjourn this to another date. And in the meantime, you have to serve the other party with the notice of motion and the affidavit. And I want the other party here in court because I want to hear what they have to say.
Okay.
So as I said, it's so fact, circumstance, and fact driven. And okay, and again, if you're doing it on notice, then it kicks in all the other requirements under the rules, is that you might have to do a confirmation, a Form
Oh, yeah.
14C confirmation that your motion is going to proceed. You have to do an affidavit of service if you're
Mhm,
required to serve the other party. So all of those things have to be completed and then uploaded.
mhm.
And again, that's part of what I do on the instruction sheets I do for people that are looking at having to bring an emergency motion is that if it's not urgent, then the filings have to go through the Justice Services website for like the online filing. Okay, if the motion is with notice, but it's going to be heard in less than 5 days, then you can actually email the documents to the court rather than uploading them all through the Justice Services one or e-filing.
Oh,
And again, everything has to be sworn and properly done and everything else. And as I said, I've seen situations where people have walked in paper copies for an emergency without notice motion and they don't get uploaded at all. That it gets done just with the basis on the paper that's filed. So it really is something that changes from jurisdiction to jurisdiction. You're dealing with
yeah.
hopefully what is very, very rare emergency situations where something really needs to be done in a hurry and the court can and will take shortcuts, but how many shortcuts and what they will actually do is really, really dependent on each jurisdiction. But it's always worth it if you really feel that you've got grounds for bringing an emergency motion, you take the steps to do that because there is a way of doing it in the system.
Can I just add a quick disclaimer to everyone here? Because these procedural information usually changes without notice. And so I just want to let people know that if they're watching this video, say a year from now, whatever, 2 years, they really should just check with the court or check with the practice directions or whatever it is for the most current
Yes.
information, because just don't take, I mean, I mean, Helena, you are an expert, so of course, everything you say is true. I know, but it's true for now, but who knows when they're going to change. So I just wanted to add some caution there.
Yes, and again, I'm gonna be your typical lawyer and to say too, is that everything that I've said is it gonna happen all the time in every jurisdiction? Is it always gonna happen the same way? No, it won't.
Mm,
And whether something is gonna happen or not, and if somebody asks me the opinion, my opinion as to whether it's gonna be A, accepted
yeah.
to proceed, and then B, even if it does proceed, will it be successful? Say, well, that depends.
Yeah.
So you're always going to be looking at it. Quite often, what most people end up doing, and I think it's a safe and a wise thing to do, is that if you honestly feel that you've got something you need to get before a judge for an order on an emergency or urgent basis,
Mhm.
go to the family court in your location where it's going to be going to court, talk to the court staff, explain the
Mm,
situation.
right.
They are quite often helpful. They cannot give legal advice or anything else, but they will listen to what you have to say and they can give you the forms that you need to complete and start working on. They will give you the resources on how to, like the online resources that are available. And they can be very, very helpful to you in that way. They cannot give you legal advice. They cannot draft the documents for you. They can't tell you what you need to put into the documents, but they can
Mhm.
give you a lot of information and direction because they might even say, well, you're gonna have to do a notice of motion and an affidavit, but really make sure you get the facts in there to show why you can't wait for a case conference on this. They will not tell you, I don't think you're going to be successful on this motion, but
Of course
they
not.
will refuse to accept a motion once they've got it and they've triaged it. They just won't tell you up front if they think you've got a claim or not, because really they can't until they've seen specifically what's contained in the affidavit and what's being asked for in the notice of motion.